We are the Moorish Society at the United Kingdom, and to get straight to the point, this is the Children's Act of 1989. What is the Children's Act? Well, it is a conservative legislation dealing with complex issues surrounding safeguarding and promoting children's welfare. The purpose of this post is to try and bring some form of understanding and justice to people who have been involved in care proceedings and the local authorities. And the reason for this is because, unfortunately, at the United Kingdom, it is our view that the courts are corrupt and there are judges who treat parents as hostiles. And in many cases, parents have had to flee the United Kingdom to seek refuge in other European countries for fear that in these family courts, where things are carried out in secret, they're losing their children to illegal acts where, in cases, the courts believe the means justify the end. And this term is called noble cause corruption, which means the courts, if they feel that a parent is a risk to their child, they will fabricate evidence to give the perception that the parent cannot look after their child. And it is for this reason parents have had to flee the United Kingdom, because they believe that they could care for the child. However, they weren't given a fair hearing and they were being denied due process. Ladies and gentlemen, take note of the following facts. The removal of a child from a parent's care can be extremely harrowing and traumatic for the child. In most cases, when local authorities receive a complaint about a child, social workers will turn up at your door with the police, often in the middle of the night. That child will be taken, placed into a car with strangers, and taken away to a foster care where the child is placed with complete strangers. And whilst the child is in foster care, the local authorities will then seek to issue care proceedings for a care order and demand that the parents undergo an assessment to see if they can adequately care for their children or child. And subject to interim orders being made, normally the child remains in foster care whilst the assessment is carried out. And far too often we have seen in courts and experienced in these courts, on the basis of that assessment, the court determines that the parent is unable to provide adequate care for the child. A care order is made. The child remains in foster care until the age of 18. And in extreme cases where the child is very young, the child would be placed for adoption. If anyone has had their child or children taken from their care, placed into a foster care, the local authorities have then gone and issued care proceedings, demanded that you undergo an assessment. Whilst the child is in the foster care, an assessment is carried out, and on the basis of that new information, that has been gathered whilst the child is in a foster care, the court then determines that you are unable to care for your child, I am afraid to say that your child has been removed from your lawful control disproportionately for unreasonable reasons and in a way which is not necessary in a free democratic society. In other words, your child has been removed from your lawful control illegally and unlawfully. We have due process in this country. The means do not justify the ends. No one is above the law, and we reserve the right to equal protection of the law. Furthermore, ignorance of law is not an excuse. It is a criminal offence at the United Kingdom to take or detain a child under the age of 16, to remove that child from the lawful control of a person who has lawful control of that child without lawful authority or a reasonable excuse. The United Kingdom government, otherwise known as His or Her Majesty's government, namely the Ministry of Justice, along with members of the Law Society, are hereby charged with the blatant criminal abduction and exploitation of children at the United Kingdom. It is not the Children's Act of 1989 to take a child from a parent, place that child into a foster care, issue care proceedings, and whilst the child is in the foster care, conduct assessment on the parent whilst the child is actually in foster care and not in the care of the parent. And on the basis of that new information that has been gathered, whilst the child continues to be in foster care, use that information to determine that the parent is unable to care for their child, upon which a court makes an order. That, ladies and gentlemen, is not the Children's Act 1989. Now, before we proceed any further, I would like the general public to take a look at this video that the government has posted on their website, providing information as to how care proceedings are conducted in a court. We would like to inform the government that the information contained within this video is incorrect and is misleading the public as to how care proceedings should be carried out in accordance with the Children's Act 1989. So, ladies and gentlemen, please be patient, take a look at this video, and we'll discuss more matters on the Children's Act.
Just start
following
the recording. This is the first case on your list, FC 267-34598, and is the matter of Wessex County Council and Logan.
This matter comes before court today following concerns regarding the care of Sophie, who's 5 months old. The application for an interim care order comes on the back of concerns by the local authority, general practitioner and community midwife regarding the mother's relationship, in which there have been allegations of domestic abuse, violence and drug use during the mother's later stages of pregnancy. These concerns have heightened since the birth, and the health visitor has reported that the child is showing signs of neglect and failure to thrive. This culminated in a police call-out to a party at the house in the early hours of Sunday morning, at which there was evidence of loud music late at night, drug use and rowdy behaviour, including that of Miss Logan, who is alleged to have obstructed a police officer. On searching the property, police found the child, Sophie, awake and crying in a bedroom. There was evidence of drug-taking paraphernalia in the child's room, and the child was distressed, cold, clearly hungry, and looked unwashed and neglected. The police took the decision immediately to take the child into care. The local authority subsequently placed the child in temporary foster care, and today they seek an interim care order to secure her well-being in a foster placement.
I'm grateful to my learned friend for his summary of the situation as the local authority sees it. However, on behalf of Miss Logan, I will say that my client denies use of any drugs, and furthermore, she denies that there has been any violence or abuse in the relationship. Having said that, the mother's position today is that, reluctantly, she does not oppose the making of an interim care.
Okay, so this is a video that has been put up on the Ministry of Justice website to inform the public how care proceedings are conducted in a court. Now, I appreciate the people in this video are actors. In the end, the representation for the parent states to the magistrates that she denies all of the allegations. However, she does not oppose the making of an interim order. We would like to advise any member of the public, if you have ever been in a care proceedings, or if you ever get into a situation where the local authorities issue care proceedings, and you have representation, and your representation advises you not to oppose the interim order, although you deny the allegations, we suggest that you get rid of your legal representation, for not only is he advising you to incriminate yourself, but the legal advice that he's providing to you is incorrect, and therefore that person is demonstrating incompetence and is potentially setting you up to fail. The reason I say this is because, in the first instance, a parent cannot incriminate themselves in care proceedings. The court must find, on the basis of the facts, that there is reasonable cause to believe the issues of Section 31 to making a care order exist. So, a parent cannot incriminate themselves. The second issue is, it's an oxymoron to say you deny the allegations, but you do not oppose the interim order. It necessarily follows that if you deny the allegations, you must therefore oppose the making of an interim order. Now, the courts should be competent enough to know this. And what should happen, therefore, is that once the parent denies the allegation, a hearing should be set to hear the facts for the making of the interim order. And on the basis of the facts that are presented by both parties, the judges must come to their decision as to whether or not there are findings of fact. That, ladies and gentlemen, is the appropriate way of dealing with care proceedings for the making of an interim order. Now, bear with me, ladies and gentlemen, because things go downhill from this point forward. Now, let's be absolutely clear. Pursuant of the Children's Act 1989, at Section 31, for the making of care and supervision order. Section 31 of the Children's Act 1989 does not in any way authorize the removal of a child. I repeat, Section 31 for the making of care and supervision orders does not authorize the removal of a child. It simply grants care, shared care of the child between the parent and the local authorities. Furthermore, the local authorities, under a care order or otherwise, do not have parental responsibility for the child. The context in which the care order is applied is at Section 3 of the Children's Act 1989 at subsection 5, where it states, a person who A. does not have parental responsibility for a particular child, but B. has care of the child, may, subject to the provision of this Act, do what is reasonable in all the circumstances of the case for the purpose of safeguarding or promoting the child's welfare. That's the context in which the Children's Act at Section 31, making care and supervision orders, are applied. Now, we have witnessed in court that the family courts have been removing children without assessments, without child welfare complaints, and placing children in foster care. And whilst the child is in foster care, they've used new information or information that has been gathered whilst the child is not in the care of the parent, and has been making care orders. And on the basis of that care order, they have been placing children for adoption without any adoption hearing, without any facts heard as to the necessity of placing a child up for adoption. And this has been going on possibly since the creation of the Children's Act 1989. So we would like to make this absolutely clear to anyone that is involved in care proceedings or may get involved in the future in care proceedings. The following. Section 31, subsection 1, the Children's Act 1989, for the making of care and supervision order, clearly states, on the application of any local authority or authorized person, the court may make an order. I repeat, on, not afterwards, but on the application of any local authorities or authorized person, the courts may make an order. What that means is, at the time the local authorities make their application to the courts, they are supposed to have in their possession conclusive evidence that the child in question is suffering or is likely to suffer a harm of a significant nature, and that harm is attributable to the care given to the child that would be unreasonable. Now, if in court proceedings there are legal advisors, then the question is, why is the court allowing children to be taken, placed in foster care, and due to the fact that the local authorities do not have sufficient information on the child, they're allowing local authorities to gather information that has nothing to do with the matters that led up to court proceedings? Why is the court allowing that evidence to be used to remove children? We have just clearly set out that that is not how the Children's Act is applied. On the making of an application, the local authorities must have in its possession conclusive evidence that the child is suffering or is likely to suffer a significant harm. You cannot take the child, place the child in foster care, and then gather the evidence against the parent that has nothing to do with the reasons why you made the application in the first instance. That is an illegal and unauthorized removal of children. Another bad practice that we're witnessing in these courts is making of interim orders on the basis that the parent is uncooperative with the local authorities. The parent has no duty of care to their children. A parent does not have to protect their children from harm. A parent only has responsibility to the child under the Children's Act and can reasonably refuse access to the child if they believe that the local authorities do not have a case, do not have information that their child is at risk, and believe that to be the case. They can reasonably refuse access to the child. And so the courts should not be hostile towards the parent and hold the parent to account simply because they refuse to cooperate with the local authorities. That is not the reasons for making interim or care orders. So we would like to make it absolutely clear as daylight that in the first instance, on the making of an application, the court must have conclusive evidence a child is suffering or is likely to suffer significant harm. Now, that information cannot be speculated. It must be based upon conclusive facts that has occurred. Because when you look under section 31, subsection 2 of the Children's Act 1989, it says a court may only make a care or supervision order if it is satisfied that A, the child concerned is suffering or is likely to suffer significant harm. Now, is means actually. Where it states the child concerned is suffering or is likely to suffer significant harm, is means actually. So as we stated, the local authorities must have, at the time of their application, conclusive evidence that is not speculated that the child suffering a harm, and not just simply a harm, but that harm must be of a significant nature. And furthermore, the harm must be attributable to the care given to the child, not being what it would be reasonably to expect a parent to give him. So on the facts we have provided in this post on YouTube, should this come into contact with His Majesty's government, we would expect the government and Parliament to carry out an investigation into the way children have been removed at the United Kingdom, possibly since the creation of the Children's Act 1989. The fabricating of evidence to take children, in particular, and especially young children, to place them for adoption to meet government adoption targets, and placing them into foster cares in lengthy care proceedings where foster placements, foster contact centres, lawyers, the courts are all profiteering financially from the child being in care. The government should carry out an in-depth investigation, and any illegal activities that is found, those people who has committed these offences should be held to account and brought to justice. The United Kingdom must stop concealing this terrorist acts that are suppressed in these covert, illegal child trafficking court venues, otherwise known as family courts, to allow our children being injured by these very dangerous individuals who are using state powers for unlawful purposes.